I have known Baldemar Velasquez for nearly half a century. He is a resident of our community in Ohio, but was born to migrant farmers in 1947. He's the first member of his family to graduate from college with a sociology degree from Bluffton College, but he has spent his life truly laboring in the vineyards, both figuratively and practically. He's been laboring in the vineyards of justice, and he's here today, I know, to speak truth to power. I know how dedicated this man is, and I really wanted to be here today to make sure that on the record, a citizen of this gravitas would be given a moment before the Congress of the United States to tell the story of the people that he's been struggling to give recognition to and justice to his entire life. In 1967, he founded a group called the Farm Labor Organizing Committee, which is based in Toledo, Ohio, and it began by handing out leaflets to Northwest Ohio farm workers. Nearly a decade later, there was an effort made by Flock to demand union recognition and a multi-party bargaining agreement. In 1983, he led a 600-mile march from Toledo to Campbell Soup headquarters in New Jersey. That isn't the purpose of today's hearing, but it's important for people here to understand this gentleman was responsible for organizing both farmers and farm workers to deal with a major processing company in order to get proper treatment of the workers. I don't know of any person in our country who has achieved what he has achieved on the labor front. And finally, in 1998, he led a 5-year boycott and protest of Mount Olive Pickle Company in North Carolina and organized workers in our country as well as in Mexico and helped to sign the only binational labor agreement that I am aware of, including the opening of an office in Monterrey, Mexico, so that workers could come to our country free of the kind of coyote bounty that they have to pay with unscrupulous labor traffickers. And he's here to talk about what happened as a result of that. In 1990, Mr. Velasquez received the MacArthur Foundation Genius Award, so truly deserved. And in 1994, the government of Mexico and its president awarded him the highest award they give to a non-citizen, the Aguila Azteca Award. Mr. Velasquez presents as a very humble and religious man. Let me tell you, he's one of the finest people I've ever met, and I'm proud to introduce him this morning.
Mr. Chairman, members of the committee, thank you for having me here today. My union represents more than 12,000 workers, of which some 6,000 are in the H-2A guest worker program. As Chairman Miller has stated, until we can protect the basic human rights of current guest workers, it's difficult to talk about expanding these programs, which would also mean the expansion of the corruption that plagued the countries of origin. The H-2A workers we represent are part of a collective bargaining agreement we signed with the North Carolina Growers Association, NCGA, with a sidebar agreement with the Mount Olive Pickle Company. The 7,000 workers in this operation are the only ones in the nation that have a dispute resolution mechanism through our grievance procedure, and the NCGA is the only group of employers to have a credible oversight of their recruitment efforts with our presence in Mexico, and because I have seen it work. Indeed, and although sometimes contentious, we have processed over more than 4,000 inquiries, grievances, and irregularities over the past 2 years. I applaud Congressman Miller in calling attention to the problems posed by the recruitment of foreign workers. Some of the initiatives proposed by H.R. 1763 are timely and overdue. Flock has paid the price for speaking out against the criminal elements that constantly latch on to any opportunity to bribe, extort, or blackmail other human beings. Foreign recruitment programs provide an additional opportunity for those types of criminals to flourish. After a series of attacks, burglaries, harassment by runners connected to recruiters, we were stunned by the tragic attack of our staff person, Santiago Rafael Cruz, who was bound and beaten to death on April 9th of this year. The police of the state of Nuevo León have detained but not charged an accomplice in that tragic murder. The detainee's criminal record bears out what we have suspected, that the attackers were a criminal element involved in predatory activity and human trafficking. The detainee had previously been arrested in the U.S. for human trafficking, drug trafficking, and, if I recall, armed robbery. If one were to ask us for recommendations gleaned from our experience and make a guest worker program viable, we would offer the following. It's important that we remove the prospects for any money changing hands in Mexico. It has been common practice for recruiters to collect upfront fees for visa interviews, visas, transportation, and recruiting costs. This opens the door for bribery and other invitations to pad the amount. The more desperate pay what they have to be hooked into the system. Secondly, H.R. 1763 offers some important measures, like making the employer jointly liable for a recruiter's action, and more importantly, protects workers from retaliation if he should complain. The American consulate should be allowed to keep a registry of repeat workers to minimize the reapplication process from 1 year to the next. This would lessen the logistics of managing large numbers of workers to be hooked into the system every year and lessen the contact with recruiters in the foreign country. Third, the worker should be afforded the same labor rights as any other worker. The right to form a union should be made easier. Workers should be given full access to all labor forums and courts to redress grievances and problems. Lacking a collective bargaining agreement, the worker should be able to transfer his visa to another employer. As it is now, if a worker gets into a contentious situation with an employer, he cannot complain, and if he leaves, he becomes undocumented and cannot work for another employer. Fourth, in the case of corporate contracted crops, those corporations should be charged a fee to offset their grower suppliers' costs for the processing fees and expenses of the H-2A guest worker. It's unfair for the grower supplier to shoulder all the risk and expenses of a legal workforce. For large corporations to balk at engaging this responsibility is to invite the further institutionalization of the thousands of undocumented workers currently harvesting crops that could be transitioned to a legal workforce. Lastly, having demonstrated an agreed upon number of years of faithful work and service, a worker should be allowed to obtain a temporary residence, or at least to adjust to a visa where he would not have to repeat an application process. This is why we support the currently pending ag jobs legislation. Finally, in all these matters, and respect to the great religions of the world and calling on my own Judeo-Christian heritage, we are reminded some of the best laws of our nation have been those that adopt scriptural principles. On this very issue, what comes to mind are Exodus 22:21, do not mistreat or oppress the alien. Leviticus 19:34, treat the alien like your native born, and especially Numbers 15, verse 15, you are to govern the alien with the same laws as you govern yourselves. I thank the committee and would be happy to answer any questions.